Good afternoon friends and welcome to the EduStat Network. Our topic of discussion today will be a continuation from yesterday. In fact, the second part of international organizations, and for this discussion we have with us in our studio Dr. Aparajita Kashyap, Assistant Professor, the University School of Law and Legal Studies, Guru Gobind Singh, Indraprastha University, New Delhi. She has been teaching for nearly a decade and her area of specialization includes international relations, politics amongst many others. And with this introduction, I would like to welcome ma'am and also request her to begin our today's lecture. Thank you, ma'am.
Yeah, very good afternoon to the viewers. Today's lecture would be a sort of continuation of yesterday's lecture. We ended with the problems that the international organizations were facing. Then there was a question towards the end. Urvashi had asked about what is the Union of International Association. So I would rather begin my lecture with that, and then I'll take you to deliberating about the various examples of international organizations that exist in the world. And herein we will be looking at different kinds of IOs. I told you that international relations now is a cobweb model. It is interconnectedness between intergovernmental organization, non-governmental organizations, civil society based organizations. There are certain individuals who become very important, and last but not the least, the most important actors of international relations, the states. So it is an interaction, interconnectedness between these several actors, and this is why the international relations is referred to as a complex web of actors. And this, I then begin my discussion with this. Now, if we just focus on the way the lecture would proceed, I ended with something important, and that was how, because it is an international organization and when it operates within the boundaries of a particular nation state, there are bound to be conflicts between the existing municipal laws and international laws. So what is the legal basis of international organization when it acts in a state? Now, there are important problems. Do we consider them as actors which are to be governed by international law, or should we, by the fact that they are operating within the territory of a particular nation state, should we allow them to be governed by municipal laws? So this is one important area of conflict, and there is one important reparation case which I am going to take up, very important case. So I just begin by saying whether the organizations only had legal personality under municipal law or also to some degree under international law. Now, when we talk about legal personality under municipal law, it includes the capacity to own and dispose of property, to litigate, to enter into contract, but all this under the municipal domain. Whereas if we talk about international law, it includes the treaty making power, the capacity to bring international claims, and in that fashion, in this action now, we have to assign a legal personality to the intergovernmental organization, and this is the most important aspect of international relations, to assign a legal personality to all international organizations. Now, if we talk about international actors in the name of international organizations, when they come to operate within a state, there are certain problems which may occur if the problem is as serious as to cause injuries, grievous injuries, or assassination of the actors, the agents of this international organization in a particular state. What happens then? How do we claim reparation for those damages that have been caused? So, to sum it up, we have to say that because it is a legal entity, there is a reparation that can be claimed for internationally wrongful acts. But with that, we have an important duty, and that important duty is to provide protection, and if that protection is not provided, these international organizations have the right to reparations. So, this is a correlative aspect where there are duties, and in respect because you have a duty, then you have to claim certain right, and this right is claim for reparation for any wrongful activity. So, we have now an IGO which has a particular legal personality. Now, where does it obtain the legal personality from? So, the legal personality, as I told you, the origin of an intergovernmental organization is by the fact that there is a treaty or a memorandum or an agreement which is signed. Therefore, the legal personality is conferred by that particular treaty or any other constitutive instrument. Now, the legal personality is not an absolute concept. It differs from case to case basis. So, we would rather say that it is a relative concept. Then with the legal personality then come specific rights, duties and powers. So, anybody who's a member of a particular international organization, or if we consider the international organization to be a legal personality, there are certain privileges, there are certain rights, duties, immunities which come with these actions, and then there is an issue of international responsibility and liability. Therefore, establishing a legal personality opens up a plethora of legal questions. Now, what are as I told you, the sources of legal personality? Where does the legal personality come up? It is from the constituent treaty, or there are certain case laws which can be cited as precedents which assign legal personality to the intergovernmental organizations. Now, as I told you, we would be looking at the reparation case. What happened, and the case was that in 1948, the United Nations mediator, and this mediator had gone, Count Bernadotte had gone to Middle East, and he was mediating in the Arab-Israeli conflict of 1947-48. During his mediation, he was assassinated by the terrorist group or the militant group in Jerusalem. This group was called Lehi, while he was pursuing his official duty as a member of the United Nations. He was a mediator of United Nations. Now, where the site of action was a territory which was under the control of the provisional government of Israel. Now, the question arose, while Count Bernadotte was assassinated, he was a Swedish diplomat. He was assassinated in Jerusalem, and he was assassinated by a militant group. Now, the question arose whether the United Nations had the capacity to make an international claim against Israel for reparation in respect of the damage suffered, and here the damage is the assassination of Count by the United Nations as the result of his death. So, did the United Nations possess the capacity to make an international claim? This was a big question. Now, this question, the reparation for injuries suffered in the service of the United Nations case, was submitted for advisory opinion of the ICJ. And basically the claim was, the United Nations claimed that there was its staff which had gone on a positive mission as a mediator, he had been killed. Does UN have the right to ask for reparation? And what was the ICJ's opinion? So, there were two basic questions which were asked, and if we look at the question, the General Assembly submitted the following legal question to the ICJ for an advisory opinion. In the event of an agent of the UN in the performance of his duties suffering injury in circumstances involving the responsibility of a state, does the United Nations as an organization have the capacity to bring an international claim against the responsible de jure or de facto government with a view to obtaining reparation? And there are two kinds of damages caused. One damage is caused to the United Nations. So, this was 1A of the question. The second question was reparation in respect of the damage caused to the victim or the persons entitled through him. Now, the court started the process of deliberation, and there were a series of verdicts given, there were a series of examinations which took place, and the ultimate result was, let's not go deeper into the question because it may just make me spill out of the lecture. So, after a due deliberations and examination of facts, the court arrived at the conclusion that an affirmative answer should be given to question 1A and 1B, whether or not the defendant state is a member of the United Nations or it is not a member of the United Nations. So, the important decision, if we summarize the important decision which was given by the ICJ, and it was read out by the United Nations Secretary General in 1950, the important decision and the claim was that a sum of US dollar 54,628 would be paid by the Israeli government to the United Nations. And this claim was based on three elements of state responsibility. So, this was a United Nations mission in a state, in Israel, and United Nations is an international organization. So, clearly the ICJ had conferred a legal personality to this IO. Now, the three elements on which the case or the claim was based, the first was failure by Israel to exercise due diligence and to take all reasonable measures for the prevention of the murder. Second was the liability of the Israeli government for acts committed by irregular forces in the territory under its control. It was just trying to shake away that this group was not under its control, but the territory was under its control. So, how does a country justify that for any act of aggression, of violence by particular groups within its own territory, it does not have control? So, the ICJ established that it was the liability of the Israeli government to have control over the acts of groups operating within the territorial boundaries. And the third claim, the third element on which the claim was based was failure by Israel to take all measures required by public international law to bring the perpetrators to justice. If they had done it, the matter would not have been taken to the ICJ. So, Israel failed to act lawfully or justiciably. It did not grant justice to the victim. And in June 1950, the Israeli government, without formal admission of liability, it did not admit the liability, but nonetheless it paid the claim. So, it was clearly established that if an agent of an international organization goes on a mission in another country where there is a problem and he gets inflicted by an injury in that particular country, he has a right to get reparation, or he has a right to get financial claims for the injuries suffered by him. Now, if we look at the charter provision, the UN, as I told you, is the biggest of international organizations, and if we look at the charter provisions of United Nations, because many of the international organizations get guided by the United Nations charter provisions. So, if we look at the charter provision in Article 104 and 5 clearly mentions that countries have responsibility, and Article 104, and I would just read it, the organization shall enjoy in the territory of each of its members such legal capacity as may be necessary for the exercise of its function and the fulfillment of its purposes. So, every territory is bound to provide certain conditions which are conducive to the exercise of the functions, and these functions are in tune with the purpose of that particular international organization. Article 105 para 1 says, the organization shall enjoy in the territory of each of its members such privileges and immunities for the fulfillment of its purposes. So, if you go as an agent of a particular international organization, and especially United Nations, you have you have to enjoy certain privileges and immunities. And Article 105 para 2 further goes on to say that the representatives of the members of UN shall enjoy such privileges and immunities as are necessary for the independent exercise of their functions in connection with the organization. And in that context then, Count was just doing his bit. He was just doing certain function to establish the purpose or aims or objectives of the United Nations, and in that connection then he had to enjoy special privilege and special rights. Now then if we look at, this was about establishing a legal personality of international organizations. Once the international organization have a legal personality, now then they can ask for claims. So there is a very definite legal procedure to be followed. It is a legal entity. It can lawfully act there. It can ask for claims. So the role of international organizations gets firmly established and entrenched, and they have more credibility by the very fact that they are a legal entity. Now, if you look at the proliferation of international organization, there is a particular trend which is involved. Now, if you look at the trend, there are three trends. One is those traditional global international organizations which existed and they continue to exist. Their importance hasn't gone down, whatever be the reason. Then there are certain international organizations, and these are called emanations, very important area of causing IOs to proliferate all over the world. So these are sub creations, or these are sub groupings of international organizations. They are created by existing IOs rather than by states. So the IOs feel that there are certain role which it has to sublet because of the principle of subsidiarity, that is, local issues are best tackled at local levels. So it creates subgroups on its own without involving the states. But definitely the members of these would be from the states only, the member states. So they are answerable to the member states, but they are creations of the IOs rather than of the states. And then there is a third important trend, which is proliferation of large and small regional organizations, and then these regional organizations become international organizations because the membership may run from more than 3 countries. So the moment you have 3 or more countries coming together on a particular issue, it becomes an international organization. But we still continue to call them regional organizations because the membership of those bodies belong exclusively to a particular region or a hemisphere or a sub-region. So this is very important. Now, if we look at some of the traditional international, global international organization, the first truly important IO which came up was the League of Nations. As we all know that the First World War had ended in disaster, and then we started deliberating on how to prevent such disasters from happening in future. And as a result, after the Treaty of Versailles, to help maintain international peace and security, this body was created. This was called League of Nations, a typical IO which had 3-tier structure. There was an assembly of all members, a council of exclusive members, only the 5 permanent members, and 4 rotating members. This is how it differs from the present Security Council, because the Security Council continues to retain these 5 members, but the non-permanent members are 10 in number. And along with the third organ, which was the International Court of Justice. The objective behind creation of League was to guarantee the territorial integrity and political independence of member states. It also wanted to establish procedures for arbitration and create mechanisms for economic and military sanctions if a country was not behaving. And it started functioning well, fine, but it failed to prevent the Second World War, and this is when the demise of League of Nations comes. So clearly the mandate for which it was made, it did not fulfill the mandate and it dies. So then we had the Second World War. After the Second World War, there were due deliberations in the world, and you had 3 important charters, 3 important conferences, the Atlantic Charter, the Yalta Conference, the Dumbarton Oak Conference, all these importantly, and there were 3 important leaders who were negotiating. Winston Churchill was one, Stalin and Roosevelt, and all these together then they drafted what is the present United Nations Charter, and United Nations comes into existence after the Second World War. The idea clearly was to prevent any great war from happening, and the other was to how to make nation states behave in case of them creating problems for other parts of the world. And then if we look at the United Nations, it has 193 member states. South Sudan is the newest entrant. The non-members importantly are Holy See and Palestine, but they are there, they have permanent, Holy See has permanent observer status because of its special unique position, very tiny population. Therefore, it has been present in the United Nations, but not in any permanent capacity. And then Palestine is another country which has been given the observer status because it has been recognized by most of the states, but still awaits recognition by United Nations. Then there are other important countries like Kosovo or Taiwan, Sahrawi. These are the important non-members, and they are recognized by some groups, some other groups do not want to recognize them, and particularly this has been seen in the case of Taiwan. Now, the constitutional document or agreement by which the United Nations was formed is called the Charter of the United Nations, and it is one of the most sacrosanct documents that the practitioners of international relations will follow. Now, often there are different kinds of analogies drawn to the UN. Is it an international organization? Is it a world government? Is it a confederation? So there are too many nomenclatures which are being associated with United Nations, and in this association then we have to question what is United Nations, and if we deliberate on all the aspects, the closest that we come to is calling United Nations an international organization, a truly international organization, and specifically it is an intergovernmental organization. Now, it has 6 important organs: the General Assembly, which is a more representative body. All the 193 countries are represented there, and each of them they send 5 representatives. Then the Security Council, which is a select body of 5 permanent members and 10 non-permanent members. It is in session throughout the year, whereas the General Assembly convenes in session from September to December. The reason why Security Council remains in session is that it is the most important body in terms of establishing the threat to international peace and security, and also determining the action that should be taken to counter this threat to international peace and security. Therefore, and it is a small body, so it can be in session throughout, the logistics involved are not too much. Therefore, Security Council remains in session throughout because of the emergent nature and function that it has. Then you have the International Court of Justice, it is the legal wing. But the problem with International Court of Justice is that any country ipso facto who is a member of United Nations ipso facto becomes member of the ICJ. So, it can bring its claim, and ICJ has only claims brought by states. This was the traditional concept. But when we saw in the reparation case, the United Nations mediator had suffered assassination, and this case was then referred to the advisory opinion of ICJ. So, an international organization's issue was referred. Therefore, saying that it is the parties to a conflict taken to the ICJ have to be necessarily states has been contradicted here. Now, the ICJ, as I told you, any member of the United Nations ipso facto becomes member of the ICJ. But the problem is that not all of them have signed the optional clause. An optional clause is that mandate, which makes the decisions of the ICJ binding on the other countries. Therefore, it's only 1/3 or 60 odd countries which have signed the optional clause. So, the decision, the nature of decision is not binding, unlike the courts of the nation whose decisions are binding on all the parties. And then we have the Economic and Social Council, which does the most important work related to culture, economy, social aspects, development. This is the ECOSOC, and coincidence is that NGOs have been granted consultative status under Article 71 of the ECOSOC. So, when we look at the role of NGOs, where do they get their mandate from? It is the ECOSOC. And the last but not the least, Trusteeship Council. The Trusteeship Council has no role now, but the very fact that the procedure for amendment of charter is very, very difficult and very stringent, therefore, it continues to remain. There have been suggestions that Trusteeship Council now should look into the areas which are referred to as global commons, or those areas which are ecologically very fragile or volatile. So, things like Antarctica or the outer space should be given to the administration under Trusteeship Council. These are some of the suggestions, although they have not been adhered to. Now, among these organs then, many of them have subsidiary organs, and the most important body which thrives on subsidiary organs is the ECOSOC. Hundreds of agencies it has. Then autonomous agencies are also part of the UN system, but these are not administratively subsidiary to any of the United Nations organs. Now, because UN, maybe this calls for a particular a specific lecture on its own, because UN is a vast organization, there are so many things to be studied within United Nations. So, that it would be pertinent to take it up in a particular specific lecture. But moving on from United Nations, I would like to go to Inter-Parliamentary Union. The Inter-Parliamentary Union is one of the most universal organizations, because it has 166 countries as members. Any country which is democratic, which practices democratic forms of selection of government, is a member. So, we have 166 members and 10 associate members. This is one of the oldest existing organizations. It was formed in 1889. It is known as the International Organization of Parliament, and Article 1 of the Statute of Inter-Parliamentary Union says that it is the focal point for worldwide parliamentary dialogue, and it works for peace and cooperation among people. And the idea behind IPU is to firmly establish representative democracy in those parts of the world who have so far been deprived of democratic governance. Now, what does it do? It fosters contacts, it coordinates, it allows for exchange of experiences between parliamentarians of different countries. So, there are Inter-Parliamentary Union congregations where we have exchanges on the model of practices, and we learn from the best practices of each other. So, this is the contribution of IPU, and India, let me tell you, is a very, very important contributor to the IPU. And India has hosted IPU delegations also. Now, leaving aside the political unions, most of the political IOs, we must come to those economic international organizations, because political economy is the most active and the most contentious area of international relations. So, we must bring our attention or focus to these three prominent IOs in the economic arena: the IMF, the World Bank and the WTO. The IMF and World Bank are the two predominant multilateral lenders, and they are often referred to as the multilateral. So, whenever you hear the term multilaterals, then it should click to your mind that they're talking about IMF or the World Bank. Now, they have different kinds of outputs, whereas World Bank and IMF are primarily dealing with loans, with economic systems correction. WTO is bothered mostly about rules of the international trading system. So the mandate is very different. WTO, as the name suggests, is about rules of the trading system, whereas IMF and World Bank are lenders of the last resort. So as the name suggests, they are more like financial bankers where countries take recourse to when they are in crisis. If you look at IMF and World Bank, then these were created as Bretton Woods sister. Both of them were created at the new Bretton Woods conference in New Hampshire in 1944. What is IMF? The IMF's most important role is the maintenance of macroeconomic stability and fix the exchange rate. It lends money to assist countries which are in balance of payment difficulties. So the focus here for the IMF is on macroeconomic stability and on balance of payment difficulties. How do they do it? IMF lends money, short-term loans at high rates of interest. But the controversy is that these short-term lendings often come with conditionalities. So the conditionalities are sometimes extreme because the countries are asked to liberalize, to restructure. And this has been particularly seen in the case of Latin American countries. For the Latin American countries, 1980s was the lost decade, and IMF was willing to give them loans, and in lieu of these loans, it was asking them to restructure their economies. And so was India asked to restructure, or the LPG that we had, liberalization, privatization and globalization of the 1990s was an outcome of the diktat of International Monetary Fund. So there are certain controversies. One controversial aspect are the conditionalities. Second is that the decision making is not truly representative of all the members who are present there. The members are often ignored because the voice that a country has depends on the SDR. The SDR also determines the quota of borrowing. So this SDR is the determining factor when it comes to saying who should borrow, how much to be lent to another country. On the other hand, if we look at World Bank is a more kind of philanthropist organization. I mean, I will not say it is a truly philanthropist organization, but it does more of works related to governance and development. It was initially designed to fund specific projects to assist those countries in Europe which were suffering from the destruction caused by the First and the Second World War. So it lent money only for post-war reconstruction and to help in development. The assistance that it provides is through long-term loans, and these long-term loans are earmarked either for rural development or for human development or infrastructure building or for bringing in good governance. So the IMF doesn't ask question about where the money that it has lent is going. World Bank asks question, it takes appraisals from the government, from the creditors, the agencies who are taking money as to where the money is being spent. Is it being spent in the name in which it was asked? So this is very important. Now the fund, but if we look at the role, both of them give money, both of them ask for interests. The only difference is that IMF provides short-term loans at a high rate of interest and World Bank provides long-term loans at a lesser rate of interest. So it's easier borrowing, but then the borrowing that you have to do comes with a long-term perspective, and it immediately balance of payment problems cannot be rectified. So if a country has a balance of payment problem, then the money that has to come is through IMF. Now these two agencies together are often referred to as the international financial institutions. They are similar in many structural respects, but are collectively quite different from most other intergovernmental institutions. They are very different, very powerful institutions, and these are the one or two organizations which are truly international, and their presence is felt worldwide, be it the developed world or the developing world. Now, if we move towards WTO, compared to the other two, which started in 1944, this comes almost 51 years later. So, we would call it a relatively recent intergovernmental organization. It incorporated the rules from the General Agreement on Trade and Tariffs, which predates to 1947. So, the references, the terms changed, but by and large the mandate was the same. It encourages and oversees negotiations that reduce general tariff levels. It brings in new kinds of goods and services into the rules governed trade system, and it generates agreement on how individual countries will put the rules into effect. So, by and large, the role is to provide level playing field to the trading partners. So, if it is a developing country versus developed country, the rules have to be at par, so that both of them can act, or they can coordinate their actions, or they can exchange their goods and services in a field which is level playing, and this is not marked by the disparity in their income standards. So, this is the role of WTO. Then it is a forum where countries often get together and they discuss openly about the trading rules, the specific quotas, the tariffs, the duties which are in position, or new duties which may be introduced. They talk about even labor standards in different countries. So, quite an important organization. Then moving to another important international organization, and this is one new area which has come up, is the intellectual property right. So, it is an IO which oversees 23 treaties dealing with issues related to intellectual property, including patents and copyrights, and this is a huge area which has opened up plethora of problems. There are a lot of controversies, and that is why we needed some international organization to keep all these issues in control. There are 179 countries who are members of WIPO, so almost you can call it universal. There are only few countries out of the 193 recognized nation states which have not become part of WIPO. It is a specialized agency of the United Nations, affiliated with rather than subsidiary to the General Assembly and ECOSOC. But the current name and the structure came up only in 1970. So, relatively it is a new international organization. Then if we move to another, it is also a kind of economic intergovernmental organization, but a very important one, and that is OPEC. OPEC is like an oil cartel of oil and petroleum exporting countries. It has its permanent headquarter at Vienna, and I told you that Vienna is a neutral country. Austria remained neutral. So, as a capital of Austria, Vienna was chosen to be the headquarter of many of these international organizations, just to emphasize the fact that these were neutral associations. What was the objective of OPEC? Now, OPEC had members mostly from Africa, from Asia, and if you look at the members, it is mostly from Middle East countries. And then we cannot say that, because then we have Venezuela and Ecuador. Ecuador of course is no longer a member, but Venezuela and Ecuador from the Latin American grouping. So, we cannot call it a regional grouping. So, it has more of an international character or global character. What is the objective of OPEC? The first and the foremost objective is to coordinate and unify petroleum policies among member countries in order to secure fair and stable price for petroleum producers. So, once they become sellers of oil, they have to be assured of a good rate of return. So, the oil price stability is a role of OPEC, And you know, the reason why OPEC came up was the oil crisis of the 1973. These countries were forced to sell their oil at lower prices, and then they came together as a cartel and they said they would not export, and this alarmed the entire world, and then they formed a grouping of their own, and then that's why the name cartel is associated, because they act like a pressure group in the world politics. It is an efficient it is an organization which ensures efficient, economic and regular supply of petroleum to consuming nations. And the third important objective is that not only from the producer's point of view, it also looks into producers, consumers and investors also. So those who are investing in the oil industry must get a fair return on capital. So those who have set up oil refineries, they also must get a fair return, and this is the role of OPEC. It has currently 12 member countries. Those who founded this organization are known as the founder members. The other countries with a substantial net export of crude petroleum and whose interests are fundamentally similar to the founding members are known as full members, and new members can be inducted by a voting of the founder members and full members. So a majority of these members, if they vote to include another country as a full member, they are allowed to do so. The other very different kind of an international organization, very different, because it is one organization which does not have a permanent headquarter. Whatever it has, there is a kind of a structure which exists at New York, but you cannot call it a true headquarter in that structural sense. Now this NAM is a very unique organization. The membership spreads across all the continents. There are 120 members and 17 observer countries, and the number of observer countries goes on increasing. They have the mandate to bring in as many observers as they want. The NAM administration is non-hierarchical, rotational and inclusive, providing all member states, regardless of the size and importance, with an opportunity to participate in global decision making and world politics. So a Cuba is equal to an India. This is NAM. This is possible only in an organization. Apart from United Nations, NAM is the only country which offers, because we are going to look at OECD, for example, which is an elite club of rich countries. So this is very different. And the NAM summit is the occasion when the movement formally rotates its chair to the head of the state, which is the host country, and this head of the state holds the chair and the office until the next summit, and then he passes the baton to the next country's head of state. So this is a rotational position that all the countries hold, and these summits can be held in any part of the world. Now, after looking at these political associations, economic associations, let us look at military organization. Although in its objective it has tried to bring in some political angle also, but by and large, the moment we say NATO, the bell that rings in our mind is related to security and military alliances. It was founded in 1949 with 12 founding members of the alliance: Belgium, Canada, Denmark, France, Iceland, Italy, Luxembourg and Netherlands, Norway, Portugal, United Kingdom and the United States. Supposedly it had to be North Atlantic, but let's see how it has evolved. Now presently there are 28 members. The purpose of NATO is to provide freedom and security to its members through political and military means, and how many times it has used this political means is again a matter to be seen or looked into. Now the objective of NATO has two aspects. One is the political objective, to promote democratic values and encourage consultation and cooperation on defense and security issues, to build trust, and in long run these exercises would help in prevention of conflicts. This is the political ambition. The military ambition is that it is committed to the peaceful resolution of disputes. Peaceful resolution of disputes. If diplomatic efforts are not enough, the military capacity needed to undertake crisis management operations, and at the slightest trigger we see NATO rushes in. NATO has been rushing into Afghanistan in a big way. It rushed into Iraq. So, does it even try to use the political angle? That is a question which we all must look into. And the founding treaty then was the Washington Treaty. Now, NATO's role has to be examined in a different perspective. If we look at the world conflicts, how has NATO found the mandate to intervene in many of the countries? And most of the time what it does is it either provides them protectorate status, thereby legitimizing its intervention in those countries as it did in the Gulf War. So, they'll provide a protectorate status, and in that manner they have the legitimacy to go and invade or intrude in that country's internal affairs. Now, if you look at another economic organization, but an elitist one, this is not a global organization, but it is a very elitist organization for economic cooperation and development, commonly known as the OECD. It is less typical of all the IOs that we have discussed so far. It has a very limited membership of 30 countries, and the membership is offered only by invitation. And it is easily a club of rich market oriented democracies. The forerunner of OECD was Organization for European Economic Cooperation, and this OEEC was created when Marshall Fund was coming to Europe in the 1940s after the Second World War to help in reconstruction and to prevent Soviet Union from deciding or providing assistance. So, to prevent the Soviet Union from providing assistance, the Marshall Fund was rushed into Europe, and to oversee the distribution of this fund, OEEC was created, and this OEEC then becomes the precursor of OECD. Now, the aid does not come free. The aid is tied to the creation and maintenance of democratic, political and market based economic system in the recipient countries. The other important thing that they take up are researches on international economic issues, particularly issues of concern to developed countries, and then the reports and statistics of OECD are very credible, and the developing countries like India very regularly sends its officers of the finance department on training as a way of learning from the practices or manners in which the OECD countries conduct their economic domain. That is a learning which many of the officers of the finance department are sent and asked to be bringing back home. If we look at another police organization, which is commonly called the Interpol or the ICPO, what is the role? And with the current terrorist attack in Paris, Charlie Hebdo, we are looking, or we are hearing more about Interpol, and what is the reason for Interpol to be so important. The Interpol coordinates the efforts among national police forces to combat crime when either the crimes or the criminals, they start crossing international borders. Then whose domain? Because territorial domain ends with the border. So, the national police, we cannot go beyond borders. This is when we need the help of Interpol. It has standard IO structure. It has a General Assembly in which all the 190 members are represented. Then there is an executive committee of 13 members elected from among the member states, and there is a secretariat which is managed by a secretary general. The headquarter is at Lyon, France, and the action, then the problem is that it goes and intervenes in other countries, but there is a limitation. The action of Interpol has to be within limits of existing laws in different countries, and it has to be in tune with the spirit of UDHR. And the constitution of the Interpol prohibits any intervention or activity of a political, military, religious or racial character in the country in which it goes. So, it does not have to take sides, it has to be neutral while it is doing its duty. Now, coming to the second set of international organizations or intergovernmental organizations, we come to the important regional organizations, and the most important regional organization is European Union. The Treaty of Rome in 1958 had created the European Economic Community, and the Maastricht Treaty established the EU under its current name in 1993. There are 28 members. The members have a common market, common currency, they have their own common environmental policy, it has its own legal institutions, developing its own foreign policy and military capability. And the most important thing is it ensures free movement of people, capital, goods and services across. So, the passport control is gone, there is no work permit that is required, Schengen visa is allowed between the EU members. So, it is one supranational institution, a true supranational institution which operates on the decisions taken by the member states. And not only this, it has its own headquarter, it has its own parliament. The members of that parliament are elected by the EU citizens every 5 years. It has important institutions like European Commission, Council of the European Union, the European Council, the Court of Justice, the European Central Bank and the European Parliament. And the Treaty of Lisbon in 2009 has amended the constitution of EU to make it more progressive and to make it more contemporary. The other regional organization, international organization, is African Union. Earlier it was called the Organization of African Unity, and through the Sirte Declaration by heads of state and governments of the OAU on 9/9/99, very interesting date, AU comes into existence. The idea was to accelerate the process of integration in the continent and to make them have an important position in the global economy. They wanted the continent to be rid of the vestiges of colonization and apartheid. Another objective was to promote unity and solidarity among the many African states. And they wanted to safeguard the sovereignty and territorial integrity of the member states, because African countries are very rich in natural resources, and this has brought it in the eyes of the colonizers, and it has been the area hotbed of conflicts because of the rich natural resources like uranium that it possesses. Therefore, the African countries felt the necessity to have a cooperation within the framework of the United Nations, and the unique thing is that all African countries are member except Morocco. The other hemispheric or intercontinental IO is the Organization of American States, which was founded in 1948. The objective was to ensure peace and justice in the American hemisphere, to promote their solidarity, to strengthen cooperation, to defend the sovereignty and territorial integrity of all the 35 independent states of the Americas, and it provides permanent observer status to 69 states and also to the European Union. This is unique. It provides an observer state to another international organization. The organization uses a four-pronged approach to implement its objective, and these approaches are based on democracy, human rights, security and development. Now, if we look at international organization and regional organization, and when we say international organization, let us keep in mind United Nations. What is the relationship between an IO and a regional IO, regional IGO? Relationship between universal organization and regional organization is clearly expressed in Article 52, para 1 of the United Nations Charter, which says, and I read it, nothing in the present charter precludes the existence of regional arrangements or agencies for dealing with such matters relating to the maintenance of international peace and security as are appropriate for regional action, provided that such arrangements or agencies and their activities are consistent with the purpose and principles of the United Nations. So, the United Nations itself allows for establishment of regional organization. The concern here is to avoid a conflict between the respective security system of the United Nations and the regional arrangement, and this is also listed in Article 53 of the UN Charter. It says that the Security Council is empowered to utilize the regional arrangements or agencies for enforcement action under its authority, and this is, that is why the controversy related to NATO crops up, because NATO has been often utilized by Security Council for peacekeeping operation, and it is justified, it is legitimate under Article 53 of the UN Charter. So, we cannot contradict this fact. Now then, we have hybrid NGOs. Hybrid NGOs are an amalgamation between intergovernmental organization and non-governmental organization, and 2 or 3 very important examples. One is the International Air Transport Association, the other is the International Accounting Standards Board, then you have the Amnesty and Greenpeace. These are very important examples of hybrid organization. The International Labour Organization is also a hybrid association. It is a very, very important association which is a tripartite arrangement between the government, employer and worker, and it aims to develop standards, develop policies, programs to better the condition of labourers in the world. Then similarly, we have the International Union for the Conservation of Nature and Natural Resources, which throughout the world aims at conserving the integrity and diversity of natural resources. Then we have the International Red Cross, which encourages the development of international humanitarian law and promotes the respect for it by the respective governments. Now, if I would be coming to the conclusion, I just like to sum up. If we look at the role that IOs have been performing, they have been providing technical cooperation to many of the states to bring about solutions to conflicts in various issues or areas. They have managed to encourage dialogue and communication among states. Whenever there is a disagreement, they have been able to foster rule-based rather than power-based dispute settlement mechanisms. They have been the agents of international community in dealing with humanitarian issues. They have changed the basic notion of foreign policy, how it works, how international relations work. They have managed to bring about a change. But the problem is that given all these mandates, given all these roles, all the beneficiary powers, the problem is that they have certain limitations. The first limitation is that they do not have the traditional resources of states because they cannot tax. Second is that they do not have independent means of force or agents or police agencies to regulate actors authoritatively. Third, they are beholden to the states that have constituted them. And fifth is that they are often co-opted by some states to promote their own interest at the expense of others. And here I would like to conclude. Thank you.
Thank you so much, ma'am, for this very interesting and lucid presentation for our students. And friends, with this we draw to the close of our lecture and also for our 2-part series on international organizations. And with this we thank ma'am. Thank you so much, ma'am.
Thank you.
And thank you friends for watching. Have a great day.